Right now, somewhere in England, there is one person the police cannot arrest. Not because he is hiding, not because he is surrounded by guards, not because he is rich enough to pay his way out of trouble, but because, in the eyes of the law, he cannot do anything wrong. His name is Charles. He is the king. And if he walked out of his palace tonight and committed a crime in front of 100 witnesses and a dozen cameras, not a single officer in the country would be allowed to put him in handcuffs. No court could try him. No prison could hold him. On paper, he is untouchable. That sounds like a fantasy. It sounds like the kind of power a child imagines a king has. But it is real. It is written into the machinery of British law, and the reasons behind it are far stranger, far older, and far more fragile than you would ever guess. Because the truth is this: the king is not above the law because he is stronger than it. He is above the law because the law itself was built in his name. And once you understand how that works, you will never look at a crown the same way again. Let us start with the thing everyone gets wrong. Most people assume the king is simply allowed to break the law, that there is a special rule somewhere that says the monarch may do as he pleases. But that is not it at all. The real idea is stranger. It is not that the king is permitted to commit crimes. It is that, legally speaking, he cannot commit one. The law does not see him as a person who could be guilty. Lawyers have a phrase for this, and it is almost 1,000 years old. The king can do no wrong. In the older books, it appears in Latin, rex non potest peccare, but the meaning is the same. The crown, as an idea, is treated as incapable of committing a legal wrong. And here we hit our first piece of jargon, so let us take it apart in plain English. When lawyers say the crown, they do not mean the golden hat. They mean the state itself, the government, the courts, the whole apparatus of official power, all bundled together into a single legal person. And at the very center of that idea sits the actual human being wearing the actual crown. The monarch is the crown made flesh. So why does that make him untouchable? Here is the clue that unlocks everything. Think about how a criminal trial in Britain is actually named. When someone is prosecuted, the case is not called the police versus you. It is called Rex versus you, the king against you. Or in older times, Regina, the queen against you. Every prosecution in the land is brought in the monarch's name. Every judge sits under his authority. Every courtroom, on paper, is his courtroom. And that creates an impossible knot. To put the king on trial, you would need to bring a case called the king versus the king. He would be both the person accused and the authority doing the accusing. He cannot prosecute himself. He cannot summon himself to his own court to be judged by his own judges under his own power. The whole system simply folds in on itself. The great constitutional writer A.V. Dicey, who spent his life studying exactly how British power works, described this royal authority as the residue of old discretionary power left in the crown's hands, the leftover magic of monarchy still humming quietly underneath a modern democracy. It is not that anyone recently decided the king should be immune. It is that the immunity was never removed. It is a fossil, still buried alive at the heart of the state. And that fossil has some truly bizarre side effects. Because once the law treats one man as the living source of all authority, strange privileges start to fall out of the idea like coins from a torn pocket. Consider this. King Charles does not carry a passport. He has never needed one. Why? Because a British passport is a document issued in the name of the monarch, politely requesting that other countries let the traveller pass. It would be faintly ridiculous for the king to issue a formal request in his own name, asking himself to let himself through. So he simply does not have one. He crosses borders as the person the passport speaks for. The same goes for a driving license. Every driving license in the United Kingdom is granted under the monarch's authority. So the king, uniquely, is allowed to drive without one. The late Queen was often photographed at the wheel of a Land Rover, perfectly legally, holding no license at all. And it gets stranger. Since the 12th century, every unmarked mute swan swimming in open water across England and Wales has legally belonged to the crown. The king owns the swans, not as a quaint tradition, as a matter of law. And it is not only swans. Under an ancient rule, whales, dolphins and sturgeon found in British waters are considered royal fish and by old custom belong to the monarch too. Somewhere in the machinery of a modern nation, there is still a line that says the king owns the whales. There is more. By long-standing rule, police cannot simply walk onto the monarch's private estates to investigate a suspected crime without permission. The king pays no income tax, no capital gains tax, and no inheritance tax by legal obligation, because the laws that create those taxes were written to apply to his subjects, not to him, though since the 1990s, the monarch has chosen to pay tax voluntarily. He cannot vote, he cannot stand for election. He is, in the strangest possible way, both the most powerful figure in the country and a person the ordinary rules were never written to touch. Now, if you are feeling a flicker of unease at all this, you are in good company. Because for most of history, the question was not, can we arrest the king? It was something far more dangerous. It was, what do you do with a king you cannot arrest but can no longer stand? And history's answer to that question is one of the bloodiest, most astonishing stories in the entire human record. For centuries, kings ruled under an idea called the divine right of kings. In plain terms, the belief that a king was chosen by God, that he ruled as God's own representative on earth, and that to challenge him was not merely treason, but something close to blasphemy. A king could not be judged by ordinary people, the theory went, because he answered only to heaven. But there was always a crack in that theory, because a crown, in the end, does not sit on a person's head by magic. It sits there because enough powerful people agree that it should. And when that agreement breaks, even an anointed king can fall. Take Edward II. In 1327, this crowned, anointed King of England was forced from his own throne by his enemies, including his own wife, Queen Isabella, and her ally, Roger Mortimer. It was the first time since the Norman conquest that a reigning English king had been removed by his subjects. Edward was locked away in Berkeley Castle, and there, in September of that year, he died. The official story was natural causes, but the rumors told a darker tale, that he was murdered and, in the most infamous version of the legend, killed with a red-hot poker. Whether or not that gruesome detail is true, the message it sent rang out across Europe. A king could be unmade. Then it happened again. In 1399, King Richard II was deposed, stripped of his crown by his rival, Henry. Richard was sent to Pontefract Castle, and there, sometime around February of the year 1400, he is believed to have starved to death in captivity. Another anointed king, another quiet, terrible ending in a locked room. But notice something crucial about both of these stories. Edward and Richard were overthrown. They were imprisoned. They may well have been murdered, but they were never put on trial. Nobody dared to stand a king in a courtroom and read charges against him because everyone still understood the deep rule that a king simply could not be judged by any court on earth. If you wanted to be rid of him, you removed him in the shadows. You did not accuse him in the light. Until one freezing January, a group of Englishmen decided to do the unthinkable. This is the twist. The one moment the whole impossible system cracked wide open. In the year 1649, after a brutal civil war, King Charles I was brought before a court. Not overthrown in secret, not quietly murdered in a castle. Publicly accused, in a courtroom, of high treason against his own people, of waging war on the very nation he was meant to protect. And the king's response cut straight to the heart of everything we have been talking about. Charles refused to recognize the court at all. He would not even enter a plea. Because, as he put it, a king cannot be tried by any superior jurisdiction on earth. He was not arguing that he was innocent. He was arguing something far deeper, that no court could possibly have the authority to judge him because all courts drew their authority from him. He was the source of the very power now being turned against him. In his eyes, the trial was a logical impossibility. And here is the astonishing part. He had a point, and the lawyers knew it. The three most senior judges in England refused to have anything to do with the case. They said the indictment was unlawful precisely because every arm of government, including every court, operated in the king's name, and Parliament had no power to act as a judge. By the ordinary rules of the land, what was about to happen simply could not be done. So the men who wanted Charles gone did something extraordinary. They invented a court. They created a brand new body called the High Court of Justice, made specifically to try a king, granting itself an authority no English court had ever claimed before. They tore a hole in 1,000 years of law and built a courtroom inside it. Charles was found guilty. He was condemned as a tyrant, traitor, murderer, and public enemy. And on the 30th of January, 1649, outside the banqueting house in Whitehall, in front of a silent, shocked crowd, the King of England was beheaded. To this day, he remains the only English monarch ever to be tried and executed. And then something even stranger happened. Having killed their king and abolished the monarchy altogether, the English lived without a crown for 11 years and discovered they hated it. The experiment collapsed, and in 1660 they invited the dead king's son back to be King Charles II. They had proven that a king could be judged and killed, and then they quietly put the crown back on the shelf, as if to say, yes, it can be done. But we would really rather it never happened again. Which brings us to the deepest idea in this whole story and the reason the king's immunity survives to this very day. The Victorian writer Walter Bagehot, in his famous study of the British Constitution, drew a line between two kinds of power. There is the efficient part of government, the ministers and parliament who actually run the country. And then there is the dignified part, the monarchy, the crown, the ceremony, whose real job is not to govern, but to command loyalty and awe, to be the beating symbolic heart that makes the whole system feel legitimate. The king's power, Bagehot understood, is not the power of force. It is the power of a story that everyone agrees to believe. And that is exactly what "the king can do no wrong" really is. Modern legal scholars like Marie-France Fortin, who has written an entire book unpicking this maxim, describe it not as a magic shield, but as a constitutional fiction, a kind of agreed-upon pretense woven deep into the foundations of the state that everyone treats as real, because treating it as real keeps the whole structure standing. But here is the modern twist, and it matters. That immunity does not belong to the family. It does not run in the blood. It belongs only to the crown itself, to the single person who actually wears it. Sovereign immunity protects the reigning monarch and no one else. Every other member of the royal family, every prince, every duchess, every cousin, is, in the eyes of the law, an ordinary citizen who can be investigated, charged, and convicted like anyone else. The shield covers one head and one head only. Even the immunity of the crown itself has been chipped away over time. In 1947, a law called the Crown Proceedings Act made the government, the crown acting as the state, answerable in court in ways it never had been before. The old idea that the crown could do no wrong has been slowly, carefully hollowed out, until what remains is a single, narrow, almost ghostly privilege, the personal immunity of the one crowned monarch. So think again about that person we started with, the one man in England the police cannot arrest. His protection is not a superpower. It is not the strength of his guards or the height of his palace walls. It is something far more delicate than that. It is a story, an ancient, elegant, slightly absurd story that an entire nation has agreed to keep telling. That the king can do no wrong, that justice flows from his name, that he cannot be judged because there is no one left to judge him. It has held for centuries. It holds today, and it will keep holding quietly, invisibly, for exactly as long as the people choose to believe it. Because one cold morning in 1649, on a scaffold in Whitehall, England learned the real secret hiding underneath the crown. The king cannot be arrested. Until one day the story breaks, and then he can.